My name is Sarah Brennan, and I want to start with the pen. Not because the pen is a dramatic thing. It is not. The pen is the most ordinary object in the world. You hold it, and you sign your name, and the signature means something, and the meaning is legally binding, and that is the entire point of a pen in a legal context. The pen is the instrument of consent. The signature is the proof of it. And the reason I want to start with the pen is this. I never held one. Not on the day they said I did. Not in the office they said I was in. Not in front of the witnesses they said were present. Not on the document they said I signed. I was not there. My hand was not there. The signature on that document was not mine. And I can tell you exactly where I was on the afternoon of the 14th of September. Because I have a receipt from a supermarket in Coventry, timestamped at 2:47 in the afternoon, and a CCTV appearance in a pharmacy on the same street at 3:12, and a phone call to my sister that lasted 22 minutes, beginning at 3:34, and none of those things are consistent with being in a solicitor's office in Birmingham signing documents that surrendered my parental rights to my son. My son is called Oliver. He is 8 years old now. He has my eyes and his father's stubbornness and a laugh that belongs entirely to him, and that I spent 14 months not hearing in person, because of a document I never signed in an office. I never entered on an afternoon that belongs completely and documentably to somewhere else. Let me take you back. Oliver's father is a man named Marcus Webb. We were together for 3 years and separated when Oliver was 2. The separation was difficult in a particular way that separations are difficult when one person wants it, and one person does not. And the person who does not want it has a family with enough resources to make the difficulty considerably worse than it needs to be. Marcus's family had resources. His father, Gerald Webb, was a property developer in Birmingham with the particular confidence of a man who had spent 40 years solving problems by throwing money at them, and had found this approach effective enough that he had stopped considering alternatives. His mother, Diane Webb, was quieter than Gerald but no less certain, and had the specific quality of a woman who had decided from our first meeting that I was temporary and had spent 3 years waiting to be proved right. When Marcus and I separated, Gerald and Diane Webb saw what Patricia Donovan had seen, and what Robert Vass had seen, and what every family in this story has seen. When a woman they considered unsuitable became suddenly vulnerable, they saw an opportunity. And unlike the others, they did not use a solicitor to pursue it. They used a forged signature. I found out about the document on a Monday morning in November. Not from Marcus. Not from Gerald or Diane. Not from anyone in the Webb family who had been present in whatever room the document had been created in, and who had known about it from the moment it was created. I found out from my own solicitor, a woman named Frances Okafor, who had been handling my custody case since the separation, and who called me at 8:45 on a Monday morning with the particular tone of someone who has received information they need to deliver carefully, and has been thinking about how to do it since the information arrived. She said, "Sarah, I need you to come in this morning. I have received something from Marcus's legal team, and I need to go through it with you in person." I asked her what it was. She said, "I would rather show you than describe it. Can you be here by 10? I was there by 9:40. She sat across from me at her desk, and she placed a document in front of me, and she said, "This was submitted to the family court by Marcus's solicitors on Friday afternoon. I received a copy this morning. I need you to read it and tell me what you see." I read it. This particular consent order stated that I, Sarah Brennan, had agreed to relinquish my application for primary residence of Oliver Webb and had consented to a contact arrangement that gave me supervised visits twice monthly for 2 hours each visit. Supervised visits. Twice monthly. 2 hours. I looked up from the document. Frances was watching me. I said, "I did not sign this." She said, "I know you did not." I know because you and I have been working toward a primary residence application for 8 months, and you have not once indicated any intention to withdraw it. And because the arrangement described in this document is so far from anything we have discussed, that I cannot construct a version of events in which you agreed to it voluntarily. I said, Francis, I did not sign this. I have never seen this document. I was not in Birmingham on the 14th of September. I was in Coventry. I have a supermarket receipt. I have a pharmacy receipt. I have a phone call to my sister. I was not there. She looked at me steadily. She said, I believe you. And what you have just told me about the 14th of September is the most important thing you have said since you walked in this door. Because if you were in Coventry on the afternoon, this document was allegedly signed in Birmingham, then the signature on this document is not yours. And a signature on a legal document that is not the signature of the person it purports to be is not a consent order. It is a forgery. The word landed on the desk between us. Forgery. I looked at the document again. At the signature on the bottom line. It looked like my signature the way a photograph of a person looks like the person. Recognizable at first glance. Wrong in ways that became apparent the longer you looked. The loop on the B was too large. The H in Brennan was not how I made it. The whole thing had the quality of something that had been studied and reproduced by someone who had my signature on previous documents and had practiced it until it was close enough to pass a quick examination. Not close enough for me, not close enough for Francis, and not, I was about to discover, close enough for a forensic document examiner who had spent 20 years looking at signatures for exactly this reason. I looked at Frances. She said, I am going to need everything you have from the 14th of September. Every receipt, every record, every piece of documentation that places you in Coventry on that afternoon. And I am going to need it today. I said, I will have it to you by noon. She said, good. And Sarah, I need you to understand something before you leave this office. I looked at her. She said, what has been done here is not a civil matter. Forging a signature on a document submitted to a family court is a criminal offence. This is not just about Oliver's custody arrangement. This is about a crime that was committed against you and against the court. And we are going to treat it as both. I picked up my bag. I walked out of Francis Ocarfer's office on a Monday morning in November, and I stood on the pavement outside, and I thought about a pen I had never held and a signature that was not mine, and a 14-month-old custody case that had just become something considerably larger and considerably more serious than a disagreement about where an 8-year-old boy slept at night. Then I got in my car and I drove to Coventry and I found every piece of paper from the 14th of September that existed. The receipts were in the kitchen drawer where I kept everything that needed to be kept, but had not yet been filed properly, which was most things, and which my sister, Rachel, had been telling me to organise for 3 years, and which I had been intending to organise for exactly as long. I found the supermarket receipt first. Tesco Extra on the Ring Road in Coventry. 14th of September. Time printed at the top of the receipt in the small clear font that supermarket receipts use for the details that matter. 14:47. 2:47 in the afternoon. A full trolley shop, not a quick visit. 31 items including the large pack of washing powder that I bought every 6 weeks and the specific brand of pasta Oliver insisted on, and 3 birthday cards for people whose birthdays were coming up in October. The kind of shop that takes 45 minutes at minimum. And that placed me in a supermarket in Coventry at a time that was entirely inconsistent with being in a solicitor's office in Birmingham, signing documents that surrendered my parental rights. The pharmacy receipt was behind it in the drawer. Boots on the same road. 15:12. 3:12 in the afternoon. 25 minutes after the supermarket. Prescription collection, which meant I had spoken to the pharmacist and given my name and waited and collected. and signed a prescription log, which was itself a record held by the pharmacy that could be requested, and that would confirm my presence independently of the receipt. I photographed both receipts, front and back, saved to 3 separate locations. Then I called my sister. Rachel answered on the second ring, and I told her what had happened, and she was quiet for exactly 4 seconds, which was the time it took her to process something serious before she started being useful. And then she said, "The phone call. I called you on the 14th of September at 3:30. I remember because it was the day after Mum's appointment, and I wanted to tell you what the doctor said. It was 22 minutes because we talked about Mum, and then we talked about Oliver's school, and I was in my car the whole time parked outside Sainsbury's." I said, "Rachel, that call is in my phone records. 22 minutes beginning at 15:34. She said, "And I was on my mobile, so it will be in mine too. My provider keeps records for 12 months. I will request them today." I said, "Can you also write a statement? A short one, confirming you called me, and where you were and what we discussed?" She said, "I will have it written by this evening." I drove back to Francis's office at noon with the receipts, and the pharmacy information and Rachel's preliminary statement and a list of every piece of evidence I had identified that placed me in Coventry on the afternoon of the 14th of September. Frances reviewed everything at her desk with the focused efficiency I had come to rely on, and when she finished, she looked up. She said, "This is strong. The supermarket receipt alone is significant, but the combination of the receipt, the pharmacy record, the phone call, and a witness statement from your sister creates a timeline of your afternoon in Coventry that is detailed enough and corroborated enough that it cannot be dismissed as coincidence or confusion. You were in Coventry. The document says you were in Birmingham. Those 2 things cannot both be true." I said, "What about the signature itself? Is there a way to prove it is not mine beyond the alibi?" She said yes. A forensic document examiner, a specialist who analyzes signatures and handwriting for authenticity. They compare the disputed signature against known examples of your genuine signature and provide an expert opinion on whether they were made by the same hand. In cases involving forged signatures in legal proceedings, forensic document examination is standard practice, and the findings are admissible as expert evidence in court. I asked how quickly we could get one. She said, "I have someone I use regularly. I will call her today. Her name is Dr. Carolyn Hughes, and she has been doing this for 20 years, and her reports have been accepted as expert evidence in over 300 court cases. If the signature is not yours, she will know." I said, "It is not mine." Frances looked at me. She said, "I know. But Dr. Hughes is going to prove it." Dr. Carolyn Hughes worked from a small office in a building on Corporation Street in Birmingham that was 4 streets from the solicitor's office where the document had allegedly been signed, and which I noticed and found darkly appropriate, without saying so to anyone because appropriate observations are not always useful ones, and I needed to stay focused on what was useful. She was in her 50s, precise and unhurried, with the particular quality of someone whose work required absolute accuracy and who had internalized that requirement so completely that it had become simply the way she moved through the world. Her office contained more books than furniture, and a magnifying lamp on a stand beside. Her desk and filing cabinets that I suspected contained 20 years of other people's disputed documents, each one representing a moment when someone had decided that a signature was a problem they could solve with a pen and a steady hand, and had been wrong. She shook my hand and she said, "Show me everything." I gave her the consent order. I gave her 6 examples of my genuine signature, collected by Frances from previous legal documents I had signed over the preceding 14 months, each one dated and witnessed and unquestionably mine. I gave her the alibi documents, not because she needed them for her analysis, but because Francis had said it was useful for an expert to have the full picture before they began. Dr. Hughes looked at the disputed signature, and then at the 6 genuine examples, and she did not say anything for a long time. She moved the magnifying lamp and looked at specific sections of each signature, in turn, and made notes in a small notebook with a mechanical pencil, and occasionally moved documents, to compare them side by side. And I sat in the chair on the other side of her desk, and I watched her work. And I thought about Oliver at school, right now building something with Lego in the lunch break, in the way he always spent lunch breaks, methodically, and with a specific vision in mind that he would defend against anyone who suggested an alternative approach. And I thought about supervised visits twice monthly for 2 hours each. And I looked at Dr. Caroline Hughes moving her magnifying lamp across the signature that was not mine, and I thought, find it. Find what I already know. She looked up after 40 minutes. She said, I can tell you my preliminary findings now, and I can confirm them in a full written report within the week. I said, please. She said, the disputed signature and the 6 genuine signature examples were not produced by the same hand. I can say that with confidence based on several specific indicators. The letter formation in the disputed signature differs from the genuine examples in 3 consistent ways. The pressure pattern is different, meaning the force applied to the pen during writing, which is a characteristic of individual handwriting that is very difficult to replicate accurately. The connecting strokes between letters are inconsistent with the genuine examples in ways that suggest the disputed signature was produced by someone working from a visual model of the signature, rather than producing it naturally from their own habitual movement. She paused. In my professional opinion, she said, the disputed signature is not genuine. It is an imitation of the subject's signature produced by a different individual. The room was very quiet. I looked at the consent order on her desk, the document that had been submitted to a family court on a Friday afternoon. The document that had been submitted to a family court on a Friday afternoon. The document that had been prepared by a solicitor who had either not known the signature was forged, or had known, then had submitted it anyway. The document that had been designed to end 14 months of custody proceedings by presenting a court with an agreement that had never been agreed to by one of the parties whose agreement it required. I said, how certain are you? She said, in my 20 years of forensic document examination, I have given expert evidence in over 300 cases. I do not use the word certain lightly. I am certain. I thanked her. I walked out of the building on Corporation Street, and I stood on the pavement, and I called Frances. I said she found it. Frances said, I know she would. Come to the office tomorrow morning. We have a great deal to do, and we need to start doing it today. I looked at the street around me. 4 streets from where someone had sat at a desk with my signature on previous documents and a pen and a steady hand, and had decided that forgery was a problem they could solve. They had been wrong. Dr. Caroline Hughes and her magnifying lamp had just proved it. Frances moved fast in the way that solicitors move fast when the situation requires it. And the situation clearly required it. She submitted an emergency application to the family court on Tuesday morning requesting that the consent order be set aside on the grounds that the signature was forged and that the document had been submitted to the court without the knowledge or consent of one of the named parties. She attached Dr. Hughes's preliminary findings, the alibi evidence, Rachel's statement, the supermarket receipt, the pharmacy record, and the phone records that Rachel had requested from her mobile provider, and that had arrived that morning confirming a 22-minute call from Rachel's number to mine beginning at 15:34 on the 14th of September. She also filed a report with West Midlands Police. Not because I asked her to, because she had an obligation as an officer of the court to report evidence of fraud in legal proceedings, and because what had been done was not a civil matter that could be resolved through family court proceedings alone, and she was not going to treat it as one. The family court response came within 48 hours. The consent order was suspended pending investigation. Oliver remained in the interim arrangements that had been in place before the consent order was submitted, which meant his living arrangements did not change, and the supervised, twice-monthly contact that the forged document had attempted to impose on me did not take effect. The judge who made the suspension order noted in her directions that the evidence submitted in support of the emergency application was sufficiently compelling to warrant immediate suspension, and that the matter would be listed for a full hearing as soon as practicable. The police investigation was opened the same week. A detective constable named Lisa Patel was assigned to the case. She was thorough and methodical, and she called me on a Thursday afternoon to take my initial account. And she listened with the focused attention of someone building a picture carefully, and she asked questions that told me she had already read the documents Francis had submitted and understood what she was looking at. She asked me one question I had not been asked before. She said, "Sarah, do you have any idea who produced the forged signature? Not who submitted the document. Who actually sat down and practiced your signature and put it on that consent order?" I thought about it. I said, the document was submitted by Marcus's solicitors. But Marcus's solicitors would have needed the document to come from someone before they submitted it. Someone who had access to my previous signatures. Someone who had the motivation to end the custody proceedings quickly, and the resources to pursue it, and the belief that they could get away with it. Detective Constable Patel said, "And who fits that description?" I thought about Gerald Webb and his 40 years of solving problems with money. I thought about Diane Webb and her quiet certainty that I was temporary. I thought about the 3 years of managing their feelings about me, and the separation and the custody proceedings and the particular desperation of people who have decided that winning matters more than anything else, including the law. I said, Marcus's parents. She said, "That is where we are looking." The investigation took 4 months. I will not give you every detail because 4 months of a criminal investigation is a great deal of detail, and not all of it is mine to give. What I can tell you is what Detective Constable Patel told me on a Tuesday morning in March, when she called to say that charges had been filed. Gerald Webb had been charged with forgery and fraud by false representation. A handwriting analyst retained by the police had confirmed Dr. Hughes's findings and had further identified specific characteristics in the disputed signature that were consistent with Gerald's own handwriting patterns, characteristics that emerged when the forged signature was examined alongside samples of Gerald's genuine handwriting. Gerald Webb had sat at a desk with my signature on a document, and he had practiced, and he had produced something close enough to pass a quick examination and not close enough to pass Dr. Carolyn Hughes and her magnifying lamp and 20 years of looking at exactly this kind of thing. Diane Webb was not charged. The investigation found no direct evidence of her involvement in the production of the forged document, though Detective Constable Patel said, carefully and without elaboration, that the investigation had been thorough on that question. Marcus was not charged either. The investigation found that the document had been produced and submitted without his knowledge, which I found difficult to believe entirely, and which I held carefully in the part of myself that had learned to hold difficult things without letting them become the most important thing in the room. I sat with all of that. Then I went to collect Oliver from school. Gerald Webb was convicted on both charges in September. The trial lasted 3 days. I was not required to give evidence because the forensic evidence and the alibi documentation were sufficient. And Francis had advised that keeping me out of the witness box reduced the risk of the proceedings becoming about the custody dispute rather than the criminal act. I sat in the public gallery on the first day, and I watched Gerald Webb in the dock with his careful suit and his 40 years of solving problems with money. And I thought about a pen I had never held, and a signature that was not mine, and 14 months of custody proceedings that had been conducted in the shadow of something I had not known was there. The jury deliberated for 4 hours. Guilty on both counts. Gerald Webb was sentenced to 18 months suspended for 2 years, with 200 hours of community service, and a fine that Francis described as significant, and that I suspected was less significant to Gerald Webb than to most people given 40 years of property development in Birmingham, that was the sentence, and the sentence was real, and it was on the record, and it was his, and no amount of money could take it off. I sat in the public gallery when the verdict was delivered, and I did not feel triumphant. I had stopped expecting to feel triumphant about things at some point in the preceding year because triumphant implies a contest between equals, and what Gerald Webb had done was not a contest. It was an attempt to remove a mother from her child's life using a forged document, submitted to a family court, and the only appropriate feeling about the failure of that attempt was not triumph, but relief and a kind of quiet fury that I had been carrying for 14 months and was only now, in a courtroom in Birmingham in September, beginning to put down. The family court proceedings resumed after the criminal conviction. The consent order had been set aside. The custody application was reconsidered on its merits, with the full history of what had happened placed before the judge. Francis presented 14 months of evidence of my involvement in Oliver's life. The school records and the medical appointments and the documented consistent presence of a mother who had been fighting for her son since the separation and had kept fighting even when a forged document had tried to make the fight look finished. The judge granted me primary residence. Oliver came home on a Friday evening in October. He walked through my front door with his overnight bag and his particular purposeful walk that he had always had, the walk of someone who knows where they are going and is going there directly. And he dropped his bag in the hallway, and he looked at me and he said, "Mum, can we have pasta for dinner?" I said, "What kind?" He said, "The right kind." I said, "I know which kind." He said, "I know you do. I made the pasta. The specific brand. The one I had bought at Tesco Extra in Coventry on the 14th of September, along with the washing powder and the birthday cards for people whose birthdays were coming up in October. The receipt that had placed me in a supermarket at 2:47 in the afternoon on the day someone had sat in an office 4 streets from Dr. Caroline Hughes's building and practiced my signature until it was close enough. Not close enough. Never close enough. Oliver ate his pasta at the kitchen table and told me about a Lego project he was planning that involved the entire living room floor and a level of structural ambition that he acknowledged might require negotiation. I said we could negotiate. He said good, because he had already decided where everything was going, and negotiation was going to be limited in scope. I told him that was not really negotiation. He said it was negotiation with a strong opening position. He was 8 years old and he was at my kitchen table, and he had his father's stubbornness and my eyes and a laugh that belonged entirely to him and that I had spent 14 months not hearing in person. I heard it that evening. It filled the kitchen the way it always had, the way it always would. Gerald Webb had spent 40 years solving problems with money, and had discovered in a courtroom in Birmingham in September that some problems do not have that solution. Some problems have a supermarket receipt, and a pharmacy record, and a 22-minute phone call, and a forensic document examiner with a magnifying lamp and 20 years of knowing exactly what a forged signature looks like. Some problems have a mother who was never going to stop. Oliver pushed his empty bowl across the table. He said, "Same again tomorrow." I said, "Same again tomorrow." He smiled. That smile was always going to be mine, and nobody was ever going to forge that.